Okay, good morning. It is 9 o'clock and we are here in an oral argument session for the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding today. Joining me on this panel is Judge Brian Lambert from Marion County and Judge Jim Edwards from Seminole County. At 9 o'clock, we have the Jennifer Dusan versus State case. Mr. Pannell, I'm going to assume that you would like 5 minutes of rebuttal unless you tell me differently. And with that, you may begin. You have the floor.
Good morning. May it please the court. My name is William Pannell and I represent the appellant Jennifer Dusan in this case. Please reserve 6 minutes of my time for rebuttal.
Okay.
As noted in the briefs, it's our position that the court should reverse Ms. Dusan's convictions for 4 separate reasons. I'm going to start by focusing my argument on issue 1A, the search warrant issue. If time permits, I'll address the other issues and I'll certainly answer any questions the court has about any of the issues. So initially, it's our position that the trial court erroneously denied the motion to suppress in this case, the motion to suppress the blood test results, because the state failed to establish that there was exigent circumstances that justified the warrantless blood draw from Ms. Dusan. And of course, this all emanates from the U.S. Supreme Court's decision in McNeely in 2013, which was issued 11 months prior to the traffic accident in this case.
Do you interpret the state's position in this case to be that almost a per se rule that anytime there's a motor vehicle accident involving possible alcohol involvement, that is an exigent circumstance in and of itself to get outside the Fourth Amendment requirements of a search warrant?
It does, Your Honor, it does seem to appear that the state is making that argument. And it's our position that our argument is explicitly rejected by McNeely itself.
They tend to rely on Schmerber, excuse me. Correct me if I'm wrong. It seemed like in Schmerber there was just one officer at the scene.
Correct. The facts in the Schmerber opinion are pretty limited, so it's hard to tell from the opinion. But as far as I can tell, there was only one officer at the scene, and in that situation, obviously, he would have a lot more to do than the situation we have in this case when there's 7 officers at the scene by 1 a.m.
And so following along with that, if your scenario here, there was only the one officer, Van Antwerp, the trooper, your position on this issue would become a little more problematic, I guess.
I have a much more difficult argument, no doubt, Your Honor.
Okay.
I would point to the court to the page 1561 of the McNeely decision itself, where they essentially conclude that just because the defendant has to go to the hospital, that does not constitute an exigent circumstance. And they say, because a police officer must typically transport a drunk driving suspect to a medical facility and obtain the assistance of someone with appropriate medical training before conducting a blood test, some delay between the time of the arrest or accident and the time of the test is inevitable, regardless of whether the police are required to obtain a warrant. And then they posit an example where a warrant will be required. And they say a situation in which the warrant process will not significantly increase the delay before the blood test is conducted, because an officer can take steps to secure a warrant while the suspect is being transported to a medical facility, quote, by another officer. In such a
am I correct in the facts in this case? The record indicate that essentially when Van Antwerp got onto the scene, the victim herself was getting ready to be transported to a hospital. Is that accurate?
That is accurate.
So that would be one less factor that he'd have to involve himself in the context of whether it's an exigent circumstance because he has to help assist with the injured person if he's the first one on the scene, which if I understood, he wasn't. There were paramedics and people like that on the scene when he got there. Is that an accurate?
That is accurate, Your Honor. My understanding is there was paramedics there that were taking her to the hospital, and he, within minutes, was advised that she was seriously injured.
Does the record indicate whether your client was injured?
The record indicates that she was examined by the paramedics. and that they recommended she go to the hospital, that she refused to go to the hospital, but the trooper took her to the hospital nonetheless for two reasons. One, to get a blood draw, and two, because the jail won't accept her until she's medically cleared by the hospital.
Was there a separate medical blood draw here? You understand what I mean by that? My wife's an emergency room nurse, so.
There was, Your Honor, and that medical blood draw was suppressed because the state did not comply with the notice requirement.
Well, they didn't have my case that I wrote that you don't like.
They conceded it, and then they didn't argue exactly the same.
Never mind, go ahead.
Correct.
And
So-
Mr. Pennell, so in the facts of the case, based upon evidence received, was that at least the allegation was that your client last drank alcohol at 5 p.m. Is that correct?
I think there was a statement attributed to her that she said she had something to drink at 5 p.m. Whether that was the last drink, I'm not sure.
Okay. But then we've got the blood draw that took place, what was it, about 10 hours later? Is that correct?
The blood draw was taken at 3:11. Sure.
Okay. All right. Thank you.
So here, unlike the situation in Schmerber, or unlike a situation where there was only one officer, we have five to six additional Brevard County Sheriff's officers at the scene when Trooper Van Antwerp arrives at the scene. We have two more troopers that arrive at the scene within 30 minutes. Trooper Van Antwerp testifies explicitly that those troopers are able to take pictures and take measurements and to interview other witnesses. So that's not something that he needs to deal with.
What is the state's best evidence construing in their favor as to why there was no effort to get a search warrant? And again, for better or for worse, I was a trial judge, but I'll expand on that. And so I many times back 20 years ago, when we used to have the ear splitting beeper that would go off when you're on call, many times I had search warrants that I signed in the middle of the night. I guess, and Marion County is a big county. I understand there's some, Brevard's long, so maybe I couldn't get to find the judge at the time. What's the state's best evidence, as you can glean from the record, that says, well, we wouldn't have been able to get a warrant anyway, so that's why, there's edging, I can't say it today, circumstances.
Judge, a good question, and I don't really have a good answer because other than Trooper Van Antwerp having a discussion with the traffic homicide investigators about getting a warrant and then deciding and we don't know the content of that conversation, and him saying based on that conversation, they just decided not to get it because of the quote timeline, but with no additional details. I don't know. There's no other evidence they made any efforts to affirmatively get a warrant.
Is there something in the record that, you have FHP out there in Brevard County Sheriff that, when FHP is doing their investigation, the Brevard County Sheriff, some protocol, they can't do the directing of traffic or making sure it's clear? I mean, I know there's some discussion, this is a major thoroughfare, so we want to make sure the traffic is flowing or what have you. Is there anything that suggests that that's contraindicated? You can't do that? Or
no, there's nothing in the record that suggests that. So there's really nothing in the record that suggests that they made any affirmative efforts to get a warrant, or explored getting a warrant, and even tried to. I know they make a big deal of the county being a large county, but there's no effort and no testimony that they tried to contact the three judges that were close by and couldn't get in touch with those. They made no effort to contact any judge. No state attorney, no legal advisor, did not attempt to create an affidavit for a search warrant. They just blanket decided not to do it. So I don't think there's any evidence in this case, similar to this court's decision in Lyles, that the officers made any effort to get a warrant or any effort to determine how long it would take. I think the trial court factually got this right. I think she came to the conclusion in her first order that and this is the most straightforward argument we have, is that, quote, the accident occurred in the middle of the night, thereby rendering any timeline for obtaining a warrant entirely speculative. So it's our position that the trial judge got that right. The key word is speculative. It's speculation. Even as we're sitting here today, we don't know how long it would have taken to get a warrant that night.
And in your view, it's according to case law, it'd be the state's burden to show it's not speculative, that they in some other case, I can't remember the case right now, but that there's some evidence that it would have taken us 5 hours to get a warrant, and that would have been, we couldn't wait that long.
Correct.
The
Based on
evidence
her,
would be destroyed by the dissipation.
correct. But so based on her finding that it was speculation, it's our position the state failed to meet its burden of proof to show that there was not sufficient time to get a warrant, or it had taken too long to get a warrant. So that it's our position the court made the right factual conclusion, but then reached the wrong legal conclusion that suppression was not required. Again, Trooper Van Antwerp did not contact a judge, prosecutor, or legal advisor. There's no evidence that any officer on the scene did so, even though there were 7 other officers there. No evidence that any officer attempted to prepare a search warrant affidavit. No evidence that the trooper asked any officer to obtain a search warrant for him, or to take Ms. Dusan to the hospital so he could do it. And all these officers are available to do that.
Mr. Pennell, when in the timeline was it were they able to do an accurate medical assessment of the condition of the victim vis-a-vis when they arrived at the scene?
The Trooper Van Antwerp testifies within minutes of arriving at the scene, he was advised that she was being taken to the hospital and was seriously injured. So, he immediately commenced a DUI, serious bodily injury investigation. Under 316-1933, as Your Honor knows, that's when, if there's probable cause of DUI causing serious injury, that's when a blood draw is allowed and when a warrant is required. So within minutes, he knew that he may need a search warrant, and still made no effort to obtain one.
And I know this doesn't help on your other arguments, but apparently he was advised by somebody that your client was the driver. You don't like that in a later part of your argument, but that, okay, this is the driver here, and Van Antwerp can start sizing up vis-a-vis probable cause as to whether he believes that your client was possibly impaired. So then that triggers certain duties that he would have, he would have to start thinking about, do I need to get a warrant? Is she going to allow a blood, is she going to be a breath test or what have you? And that's all part of the factors here.
Correct, Your Honor. From his testimony, he believed in short order upon his arrival that the victim was seriously injured, that Ms. Dusan was the driver, and that he had a potential DUI situation. So within a very short period of time, he should have been on notice that the requirements of McNeely were applied and that a search warrant was required. So really, under the facts of this case and based on the evidence presented by the state at the suppression hearing, it's our position the state failed to meet its burden of proof, and that the trial court erred in denying the motion to suppress, and that the error was harmful to Ms. Dusan because the state focused repeatedly on the blood test results in closing argument 10 separate times, including arguing that the 0.13 blood alcohol level created a strict liability offense on page 746.
Well, let me ask you briefly about one of the other issues about the sufficiency of the FDLE regs. If we assume the judge was wrong in not holding a hearing.
Sure.
And let's follow another step. But let's say your motion was granted after a hearing. Would the result then be that there would be you could not instruct the jury that there's a presumption of impairment at a certain level, and then the state would simply have to try to get the evidence in, by showing it was reliable evidence and then, relevant to whatever the issues were? Would that be the net result of what your motion would have accomplished if granted?
Two results: that they wouldn't get the presumptions, and secondly, their ability to get the evidence, make the evidence admissible would have been more difficult. Instead of simply establishing compliance with the rules. They'd have to step by step explain through what they call the traditional predicate that it was scientifically reliable. And they were not required to do that in this case because of the court's ruling. So Ms. Toussaint was prejudiced as a result of that ruling.
But there was no presumption instruction given though here.
There was no presumption, but her prejudice was that they had the shortcut admissibility.
Yeah, part two of what you just said. You got the benefit of not having the presumption instruction given for whatever reason. I have to go back and look, but your issue is they wouldn't have been able to get the evidence in if the regulations were deemed insufficient here.
Correct, Your Honor. And I'll reserve the rest of my time for rebuttal.
Okay. All right, Ms. Nealon.
May it please the court, counsel, good morning. Kelly Nealon on behalf of the state of Florida. It is the state's position that there were exigent circumstances in this case. And so there was, under the exigent circumstances, exception to the warrant requirement, this blood was admissible.
Nobody made any effort to secure a search warrant, did they? I mean, a warrant for the blood draw, correct?
That's correct.
And even the discussion about how long it would take was not, this happened to us last week, this happened to us yesterday. It was more just a general discussion of, it really takes a long time. Sometimes the state attorneys won't answer. It's hard to find a judge and so forth, correct?
That's correct. That's correct. There was no effort to get a warrant because the officer believed he had exigent circumstances. And in this case, and that it would take too long to get a warrant. When you have alcohol dissipating, any time is pretty much too long to wait for a warrant. Now that's the McNeil.
But Ms. Nealon, don't you always have the issue of time and alcohol dissipating? I mean, that's always an issue in these cases. Yes, I think what we're getting at is there was absolutely no preparation even taken, any effort by law enforcement to even give the judge the benefit of what is the approximate amount of time or the to give the trial judge what is the approximate amount of time that it would have taken to get a warrant.
Well, and I think everyone seems to be overlooking the fact that in order to get a warrant, you have to have probable cause. And it's called developing probable cause. You don't just walk up, see an accident and go, oh, she must have been drunk. Let's get a warrant.
Well, how long do you think it took for the officer to get to the scene to recognize first, have the person identified as the driver? There was one person that was being assessed by the medical personnel there who was obviously not in good shape. And then you have the person identified as the driver. There was an observation of the smell or odor of alcohol and some physical indications that there may have been impairment. What else do you need? You already have a serious injury and you've got the issue that the alcohol issue, or at least some type of impairment issue within minutes of arriving at the scene. I mean, shouldn't it have started right there? Somebody figure out who's the on-call judge, right?
No, I don't think so. You have to investigate the case. This case did not go to trial for 5 years. And the police have to investigate a case. They have to have a case that's airtight when they go to trial. They have to collect all the evidence. Trooper Van Antwerp arrived on the scene at 12:30. He conducted his investigation. By the time he talked to her, gave her the field sobriety tests, she declined to give a voluntary blood draw. She declined to do it under the implied consent law. It was 2:17 in the morning. He arrested her and he had to take her to jail to get her medically cleared and have blood drawn anyway. And figuring it would take additional time at that point to get a warrant, but he already had probable cause, he went ahead and did the legal blood draw as well, which under 316-1933, there's no requirement in that statute for a warrant.
So are you arguing it took him roughly 2 hours to establish in his mind probable cause when he's told from the get-go she's the driver, and now he's talking to her, and so he's having a sense as to whether she's impaired or not, and he knows there's some serious injury involved with the victim here. I mean, as I read your brief, and that's why I asked Mr. Pinnell, it almost seems to me the state here is taking a position that anytime you're relying on Schmerber's language in Schmerber, which is somewhat broader, anytime there's a motor vehicle accident involving alcohol, that there is some kind of almost per se exigent circumstances.
It's not,
You're
I'm
not-
not,
it's not, well, let me, is that your position?
it's not that it's per se, but according to the cases, that pretty much is the additional factor.
Well,
In
that's,
addition
well,
to-
then you're saying that. Then you're saying that's the additional factor that, okay, if there's an accident with alcohol involved, that it takes it past the, get the warrant under McNeely, that you now have to go get it. And if that's your position, then tell us, and then we'll address that, I guess, an opinion as to whether that is. If that's not your position, then I get it when you have an officer, like apparently in Schmerber, an officer on the scene. If you have 7 officers here, I'm trying to figure out if it's not per se, tell me a scenario which would not be exigent circumstances involving a motor vehicle accident with alcohol. I'm at a loss because you got 7 people who can direct traffic, do this, do that. One person can go run and get the warrant. Isn't that?
You have a more extensive investigation that has to be done in a case such as this. This is not like a rear end collision where nobody's injured and all you're facing is potential DUI, or as the McNeely court called it, a simple DUI. I mean, they distinguish the cases where there is, and in McNeely, exigent circumstances were not argued. It was simply argued that the dissipation of alcohol is in and of itself a sufficient exigent circumstance.
I get that. I understood what the limited issue that was being asked to be resolved by the Supreme Court in McNeely. But I guess what I'm saying here is, it sounds to me that you don't want to say the words, but the words that how I'm interpreting your position in your brief is that motor vehicle accident with alcohol equals exigent circumstances as a matter of law, therefore no search warrant required. If that's your position, then that's what we need to address as a panel or as a court.
Well, I don't think that this court has to make a per se rule in this case. I think reading the cases that have come out since McNeely, no court has said it's a per se rule, but they pretty much all have held that those are exigent circumstances.
Well, let me respond then. If you're saying we shouldn't make it a per se rule, then you have 7 officers at the scene. I'm having a hard time with the concept then, all right, we just don't have the time because we have so many things to do. We don't have the time to get a warrant when there's 7 of them. If there's one, I'm kind of with it. I get it. You can't, you can only be in so many places at one time, but there's 7. If that doesn't alleviate the exigency of the scenario, what if there's 20 officers? I mean, I'm not trying to be silly or facetious, but I'm not getting the state's or your argument here today.
It depends on what all those officers are doing. Trooper Van Antwerp was the traffic investigator. And I believe all the cases I've ever done, that's the Florida Highway Patrol comes and investigates these accidents.
Okay.
And you have the officer who is responsible for taking measurements, determining cause, talking to the driver of the car, and again, developing probable cause and making a case. This is something that's going to have to be proven beyond a reasonable doubt. You can't just have officers running around going, oh, well, yeah, I think I saw this and I think she did that. I mean, this all has to be documented. And that's why there is a traffic investigator who's responsible for bringing all these facts together.
Ms. Neeland, who was the trooper who was responsible for finding out who the on-duty judge was to sign the warrant in the middle of the night?
There's no evidence that there was a trooper that was responsible for that.
Okay, wasn't that going to have to be obviously something that needed to be done if a warrant was going to be secured?
If there was probable cause, but we have to start at step 1. You have to investigate and get probable cause. And while you're investigating, you're also investigating the criminal case. What charges are going to be filed? What charges are you going to be able to prove down the road?
Well, that seems to lend itself to a slippery slope, and I'm not maligning anybody here, but I mean, if I'm understanding what you're saying, if I stay out on the scene long enough in the process of trying to establish probable cause, and the alcohol is dissipating while I'm doing that, then that kind of morphs into, well, I can't get a warrant now because look how much time it took me, as opposed to here's an accident. We know who was involved in, or the officer or trooper knows who's involved in it. The trooper is immediately assessing whether this person's impaired. I mean, at some point, he can go start the process of getting a warrant. And then I guess if he decides later on during the process of the investigation, he can have somebody else go get the warrant. If he decides, you know what, after all, I don't think there's probable cause, then they just don't execute the warrant. Isn't that how it works theoretically?
Well, theoretically, what you have to have, and you have to prepare to even getting an e-warrant these days. It's not an immediate process.
I get all that. I mean, you're talking to a guy who executed signed search warrant. I get all that. I understand that. And that's why I'm having a hard time. Maybe you have the disadvantage of having a trial judge on the appellate panel today. They did that all the time. I mean, it's not like I was woken up every night, but it's not an infrequent event for trial.
No, it's not an infrequent event, but it also takes time to prepare the warrant. You have to, there was testimony. You have to do your affidavit. You have to get a hold of an assistant state attorney to read it, to review it. Any corrections have to be made on it. This is all before you even contact the judge. Trooper Van Antwerp said, I have probable cause at 2:17 a.m. when I arrested her. And there's nothing to refute that. There is nothing in this record to show that Trooper Van Antwerp was delaying anything so that he didn't have to get a warrant. And I think we also have to remember at that time, 3/60/1933, and it still was in effect, he under state law had to take her blood once he had probable cause and knew there was serious bodily injury in this case. And that's why I made the alternative argument that the good faith exception should apply under those circumstances. I mean, there's no evidence that anybody here they were simply trying to investigate this case. This was an extremely serious accident that would have to go to trial.
So you're saying under 316-1933 at the time that once there was evidence of serious injury, or let's say the victim had died at the scene and the trooper was aware of it, he had to take the blood and he doesn't have to get a warrant at all. Is that your position?
If a law enforcement officer has probable cause to believe that a motor vehicle driven by or in actual physical control of a person under the influence of alcoholic beverages, any chemical substances, or any controlled substances has caused the death or serious bodily injury of a human being, a law enforcement officer shall require the person driving or in actual physical control of the motor vehicle to submit to a test of the person's blood for the purpose of determining the alcoholic content thereof.
Okay, so then this is really not a Fourth Amendment case at all. You're saying, tell me if I'm hearing this wrong. So once he said, okay, I'm now aware this is a serious injury, I've now decided probable cause she's impaired, I'm taking her to get a blood draw, I forget the Fourth Amendment, we don't have to talk about that. Is that, am I misunderstanding what you just said?
No, because some of these statutes have come into question post McNeely, and whether you can, what's really consent, what's not consent. So, and that's the thing in this case, the officer has to have probable cause to order a blood draw. So
that's what I'm asking. So you're saying once he made it at 2:17, he found probable cause. And let's say he now knows that the victim is seriously ill, or injured or dead. I don't know when the victim died, no disrespect to anybody. So at that point, he has to take it and he doesn't have to get a warrant. Is that?
That's under the statute. That's how the statute reads,
right,
yes.
So then why is Bill Pennell wasting all of our time? I'm not being silly per se, but I mean, okay, if that's it, then we're having a lot of Fourth Amendment discussions here. You're basically saying, if there's no dispute about probable cause, he has it, victim's seriously injured, he thinks that the defendant's been impaired by alcohol and caused the accident, therefore off you go to the hospital, we're getting your blood. I don't care if you consent or not, I don't care about getting a warrant.
Because these statutes have come into question since then, but they weren't under question in 2014 when this officer directed that her blood be taken because he had probable cause and he had learned that she was extremely seriously injured.
This happened post McNeely.
It did.
All right, and has the statute 316-1933 been modified since McNeely to?
I don't believe it has, no. And that was one of the findings.
Why wouldn't our decision in Lyles say the good faith exception really is not a valid argument in scenarios post McNeely when the blood draw is taken without consent?
Well, I think their argument is, along with McNeely, that you need a warrant for a blood draw, that some of these statutes that just say a police officer can make his own probable cause determination may not be valid. This statute was never challenged, though, as being unconstitutional or a violation of the Fourth Amendment. So That's what I'm saying. At the very least, the officer acted in good faith in reliance on this statute in case this court determines that there aren't exigent circumstances here.
Going back to the Fourth Amendment again, there's no proof that if anybody there had called at 2:17 or whenever she was arrested, that they couldn't get a warrant by 3:30, 4 o'clock. There's no proof, is there?
No, there isn't. But I don't think that's a requirement under the exigent circumstances.
But the
argument.
The officers at the scene took steps to say, well, there could be a death. Therefore, somebody get the homicide investigators here. But the fact that somebody early on thought there could be alcohol involved, nobody said, find out who the state attorney on call is or find out who the duty judge is so that if we do need a warrant, we can get one quickly. Nobody took that step, right?
Correct. And at this time, while they're still doing their investigation, the alcohol is dissipating. And that's what the exigent circumstances exception to the warrant requirement is. I don't see.
Missouri versus McNeely, they wouldn't have bothered all that ink and paper typing it up if they could have just easily said there is a per se, because otherwise what you're talking about and what Judge Lambert's been asking you, when would there not be exigent circumstances with an injury causing alcohol related car wreck? There always would be under what you're arguing.
And I would say, yes, there probably would be. There may be maybe a case where there's a very minor traffic accident or something, but in a case such as this, where it is such a major accident, there is such serious bodily injury, it requires a lot more investigation that takes up the officer's time so that they are not getting a warrant.
Okay, so your answer then is yes, it is per se. If it's a motor vehicle accident involving death or serious injury, and the prospective defendant has alcohol, there's probable cause to believe that's a factor in this, then it's because alcohol is dissipating. It's per se exigent circumstances.
As you just added now, if there's death or serious bodily injury, yes, I think there may be a minor traffic accident where that doesn't apply, but
right.
I mean, that's a significant factor to add to the exigent circumstances.
Right, and in Schmerber, I don't even know there was an accident in Schmerber, but I mean, so no. And that's the issue then here is Van Antwerp knew the victim was seriously injured. He had reasonable belief that would happen. And early on, he had reasonable belief that Ms. Dusan had been drinking and that she was the driver and that she was, certainly likely the cause of the accident. I mean, so there was at least something, as Judge Edwards said, there was something that triggered, okay, this part of the team needs to go start the warrant process. Other people direct traffic. Other people, Van Antwerp continue on with his investigation. I mean, it seems like you're arguing it is per se. When there's death or serious injury and there's alcohol involved, you don't have to get a warrant because it's per se exigent circumstances. If that's it, that gives us the template to work on.
Yes, I think in a case where there's death or serious bodily injury in the middle of the night, when there are a number of factors that have to be investigated and handled, then yes, it is.
Okay, 2 a.m. or 2 p.m. Judge is at the courthouse. Judge is at his house 5 miles away from this accident, let's say. What's the significance there other than we assume the judge is sleeping at the time of the 2 o'clock?
I think the difference is there's more investigation required in these cases where there's death or serious bodily injury. This is not a case where someone's weaving down the road and the police officer closes the door.
Counsel, I'm not questioning that. I'm saying, okay, my question is now, you seem the factor is it's 2 a.m. Okay, 2 p.m. I'm the judge sitting at the Ocala courthouse there. I'm the judge sitting in my house in Marion County. I'm closer to the accident at my house than the courthouse. You need to come get a warrant. What's the significance about it being 2 a.m. other than people are sleeping?
That's a pretty big difference because there was testimony
I'm just trying to get the parameters of what your position is. That so it's 2 a.m. Judge and state attorney are sleeping as opposed to theoretically they're not sleeping at their house at the office at 2 o'clock.
And there's also more than one state attorney at the office during the day rather than at 2 o'clock in the afternoon. So So again, it's our position that there definitely were exigent circumstances in this case due to the all the investigation that had to be done. In addition to the dissipation of the alcohol, if the court doesn't find there's exigent circumstances, then the officer could in good faith have relied on section 316, 1933. And then finally, I believe that the state would have gotten a conviction even without the blood results in this case because of all the other evidence that there were 4 witnesses that testified that she appeared to be impaired. She smelled of alcohol. She declined several of the field sobriety
Not really
exercises.
that's not really the harmless error test, though, that there were some other evidence.
No, it's not that there's some other evidence. No, it's not overwhelming evidence. No, that's not the test. That's not what I'm arguing. It's just would the jury have reached the same verdict, though, based on all the evidence that they heard? And yes, I think they would have. The jury saw her. They showed videos of her taking the field sobriety test. They saw video of her in the police car being transported to the hospital and to the jail. So it was, I mean, the jury certainly could judge on its own, in addition to all the testimony of the police officers as to how she was acting and behaving that night, whether she was under the influence.
And Ms. Nealon, you're out of time.
Okay, thank you. I would just ask this court to affirm the order of the trial court. Thank you.
Thank you. Mr. Pennell.
Hey, please the court. The state is asking this court to disregard the binding precedent of McNeely and Lyles. McNeely itself rejected a per se rule, laid out an example where there was a need to go to the hospital and said there was still would need to be a warrant. In Lyles, there was 2 separate cases before this court in Lyles where there was a serious bodily injury and death situation, and the court found there was a 4th Amendment violation for failure to get a warrant. So
this is your response. This is your response to the good faith argument here. Is that?
Yes, and Lyles says quote, post McNeely, you have to read the warrant requirement into 316, 1933, and this court's case law and all the case law is clear that even 1 day later, after a decision is issued, the police are on notice and have to apply that decision. So based on McNeely and Lyles, we'd ask the court to reverse this conviction because the trial court should have granted the motion to suppress, and state cannot meet its burden to show that the error was harmless under the facts of this case. So we'd ask that the court reverse. If the court has no other questions, I'll rely on my previous arguments.
All right. Judge Lambert, Judge Edwards. All
All
right. Thank you,
Good.
counsel. We are in recess.
Thank you.